This is Barry Zalma, speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to talk about sovereign immunity for a state, and when a state does not buy insurance to protect itself against certain risks. That fact alone establishes that the state did not waive its right to sovereign immunity, and that immunity will defeat any suit against a city or state. The plaintiffs appealed from the trial court's order granting summary judgment in favor of defendant, the city of Winston-Salem, in a case called Livingston, Flome, Maputor, Georgina, Michael, Shergi, and a bunch of other people versus the city of Winston-Salem. The Court of Appeals of North Carolina on August 6, 2024, unsuccessfully sought evidence of waiver of sovereign immunity and therefore affirmed the decision of the trial court. It all began because in the summer of 2019, the plaintiffs applied for a $100,000 loan via the city's small business loan program. In August of 2019, Flome Mawutor allegedly received verbal confirmation from Stephen Harrison, a small business development specialist for the city, that plaintiff's loan request had been approved and that a written letter of approval would be sent the following week. Plaintiffs alleged that Harrison was in routine communication with the plaintiffs over the ensuing months and repeatedly promised that the loan would close soon. The loan eventually closed in July of 2020, almost a year later, when plaintiffs signed a loan agreement with the city. On 14 August 2020, the city dispersed the loan proceeds to the plaintiffs. However, the plaintiffs claim to have lost significant business opportunities and goodwill as a result of the delay in receipt of the funds. Plaintiffs sued the city. The city moved for summary judgment on the grounds of sovereign immunity, and that motion was granted. Summary judgment, of course, is appropriate if there is no genuine issue as to any material fact that any party is entitled to a judgment as a matter of law. With regard to tort claims under the doctrine of governmental immunity, a county or municipal corporation is immune from suit for the negligence of its employees in the exercise of governmental functions, absent waiver of immunity. The North Carolina Supreme Court has repeatedly explained that a governmental function is an activity that is discretionary, political, legislative, or public in nature and performed for the public good on behalf of the state, rather than for itself, while a proprietary function is one that is commercial, or chiefly for the private advantage of the compact community. The first step in determining whether a function is proprietary or governmental is whether and to what degree the legislature has addressed the issue. Nevertheless, if an action has been designated as governmental or proprietary in nature by the legislature, that's the end of the inquiry. The city asserted that at the time the city's small business loan program loaned $100,000 to the plaintiffs, the North Carolina General Assembly had specifically indicated that the expenditure of funds was for community development and was a governmental activity. Regarding the second step, the city asserted that the money to operate the city's small business loan program comes from housing and urban development block grants relating to neighborhood revitalization strategy areas. Since the program or activity in this case can only be provided by a governmental agency, the city concluded that it is necessarily governmental. Was the immunity waived? It is well established in North Carolina and across the country that a city can waive its immunity by purchasing liability insurance. However, in this case, the city's risk management averred, that is, he filed a sworn statement, that the city had neither purchased nor had it in effect any liability insurance to cover such claims as are alleged in plaintiff's complaint. As plaintiff's complaint failed to allege that the city waived its governmental immunity, the tort claims cannot survive the city's assertion of immunity as an affirmative defense. Therefore, the trial court properly granted summary judgment in the city's favor as to plaintiff's tort claims. Then there's a question of whether or not immunity applies to plaintiff's breach of contract claims. Rather than claims sounding in a tort, a local government waives its governmental immunity when it enters into a valid contract to the extent of that contract. However, plaintiffs failed to prove that the lender promising funding was a valid contract, since they could not prove that there was an offer and acceptance of the offer or the tendering of consideration, and therefore the city had not waived its governmental immunity from suit, and plaintiffs cannot overcome the city's affirmative defense. In my opinion, suing a governmental entity is often difficult when the governmental immunity defense is raised. Tort claims are only waived when the public entity obtains insurance or there is some other affirmative statement of waiver of the immunity. None existed in this case, and the summary judgment was affirmed. And it was also affirmed as to breach of contract because there was no contract established. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. You can subscribe to the blog at the site, and you'll be given notice of every blog posting, usually 5, sometimes 6 a week. And you'll also gain access to the more than 4,850 blog posts. You can also subscribe to the videos on rumble.com and youtube.com. And if you do, I'd appreciate it if you click on the like button for YouTube or the thumbs up button for rumble.com. And please tell your friends and colleagues about this blog and the video so that they too can subscribe. And if you're interested in further detail about insurance, insurance claims, insurance fraud, and insurance law, please consider, for a very small fee, subscribing to my Substack publication. Thank you for your attention.